Kenya's High Court ruled on Friday that case challenging Deputy President Gachagua'S impeachment should be referred to the Chief Justice. Kenya's parliament voted on Tuesday to impeach Gachagua on 11 charges, including enriching himself and stirring ethnic hatred. The deputy president denied all the allegations and said the case was absurd.
As courts do not exist to serve the intellectual stimulation of elitists, but to serve the public in matters of great concern to them. And this one is one of those rare occasions that the court should arise to the occasion and serve the public with all the resources that it can possibly summon. In my view, despite stiff opposition by the respondents, it is my considered opinion that these petitions raise weighty constitutional questions that fall under Article 163, B and D2. Hence, I am persuaded to refer them to the Chief Justice for empanelment of a bench. The linked petition shall be petition number E522 of 2024. The rest to be forwarded alongside this file to the Chief Justice are petition number E509 of 2024, E537 of 2024, E528 of 2024, E525 of 2024, and E506 of 2024. So that is the decision of the court.
The fate of Deputy President Gachagua now lies with the Senate, but he still has a resource in the High Court should the senators vote to uphold the resolutions of the National Assembly impeaching him. Article 145 of the Constitution states that the Deputy President has the right to appear before the Senate to be heard before the Senate's vote on the impeachment charges. If at least two-thirds of all senators vote to uphold any impeachment charge, he will cease to hold office, but he can petition the High Court. Lawyers are, however, divided in opinion as to whether Mr. Gachagua will get orders at the High Court staying the impeachment should senators vote to kick him out of the office. Lawyers Elias Mutuma said Mr. Gachagua will move to the High Court as a matter of right to seek conservatory orders. The same was buttressed by advocate who is among the battle of lawyers defending Mr. Gachagua and who asks not to be named as he is not authorized to speak on behalf of the team. The lawyer said the team is sure of obtaining favorable court orders should the Senate go ahead and uphold the impeachment of Mr. Gachagua. According to the lawyer, the National Assembly failed the first test of public participation, which was held last week. The lawyer said Parliament may have added an extra day following a court order, but was there a reason for notice or reasonable opportunity? He said that Mr. Gachagua was not given a fair hearing and his team was prepared to argue the case all the way to the Supreme Court. Courts have clearly stated that public participation must be purposive and meaningful, not cosmetic exercise or illusionary. But lawyer Adriana Kamotho had a different view, stating that the process so far has adhered to all the requirements of the law and the Constitution. He said public participation exercise is not referendum per se, but an opportunity for Kenyans to air their views. The die is cast for Deputy President Gachagua after 282 members of the National Assembly voted to impeach him on Tuesday. Gachagua'S West MP Mwangi Mtuze tabled the impeachment motion and the floor was opened for debate, after which the second in command pleaded his case. Gachagua'S passionate plea was, however, futile as more than two-thirds of lawmakers voted to ask the outspoken DP. This was not the first time. It's the past week where things went wrong for the former Mathira MP. When he addressed the faithful during a prayer meeting at his current residence, Nairobi, on Sunday, Deputy President Gachagua cut the figure of a subdued man. The combative politicians appeared to have had a moment of self-reflection. Ostensibly, after the day's sermon, he sought forgiveness from the president. The DP appeared crestfallen after the 282 members of the National Assembly opened their signatures in support of an impeachment motion against him. At the same time, 2 days of public participation on his Ouster bid were held across the country. The process, which started at the county level on Friday, was scaled down to the constituency level on Saturday following court order. The decision was in response to a petition filed by Kirinyaga women Representative Jane Maina, an ally of the DP. The DP suffered a setback after courts declined to issue order to stop the impeachment motion following 19 similar petitions. Chaos was witnessed in parts of the country during the public hearings. In Nairobi, tempers flooded at the Bomas of Kenya, with some contributors terming MPs as selfish and unable to present their voters. Activist Morara Kebosaso was roughed up and had to leave the venue. Kenyans speculated about Ruto's silence on the issue, wondering if calls from some citizens to dismiss his entire administration had shaken the head of state. The impeachment motion against Gachagua is viewed by President Ruto's ally as symbolic break with the vote-rich Mount Kenya region. There is belief that the president knows he has already lost Mount Kenya votes and is thus looking to form an alliance elsewhere.
As courts do not exist to serve the intellectual stimulation of elitists, but to serve the public in matters of great concern to them. And this one is one of those rare occasions that the court should arise to the occasion and serve the public with all the resources that it can possibly summon. In my view, despite stiff opposition by the respondents, it is my considered opinion that these petitions raise weighty constitutional questions that fall under Article 163, B and D2. Hence, I am persuaded to refer them to the Chief Justice for empanelment of a bench. The lead petition shall be petition number E522 of 2024. The rest to be forwarded alongside this file to the Chief Justice are petition number E509 of 2024, E537 of 2024, E528 of 2024, E525 of 2024, and E506 of 2024. So that is the decision of the court.